Hi, I'm Jim Covington. Today is September 2nd, 2015. I'd like to welcome you to this week's issue of ISBA Statehouse Review. The General Assembly is really not going to have a veto session as they traditionally do in the past in late October and mid-November, or mid-November and early December, because since they've been in continuous session, the requirement that they address amendatory vetoes and total vetoes within 15 days of being placed on the calendar is requiring them to take action now. So for today and then next week, I think the General Assembly will address nearly all of the amendatory vetoes and total vetoes that have been issued by Governor Rauner. I'd like to talk to about six of those today, some of which are going to be acted on by the House of Representatives today. The first one is amends the Condominium Property Act, House Bill 2644, introduced by Representative Kelly Cassidy of Chicago and Senator Heather Staines of Chicago, and it deletes a provision in current law that allows unit owners to enforce a provision in a declaration that otherwise would be void and ineffective if at least 75% of the owners approve at any time after the election of the first unit owner board of managers. Governor Rauner vetoed this because a total veto because he believes that this is a unnecessary restriction on the rights of condominium owners with respect to their property. The next bill is House Bill 218, which decriminalizes small amounts of possession of marijuana. It's introduced by Representative Kelly Cassidy of Chicago and Senator Mike Nolan of Elgin, and it imposes a minimum fine of $55 and a maximum fine of $125 for possession of 15 grams or less of cannabis. It establishes a per se standard for cannabis DUI of 15 nanomillimeter blood or 25 nanomillimeter saliva instead of a trace under current law. If you've ingested marijuana 28 days ago and there's still a trace left in your system, that's an automatic per se violation of the DUI laws. That's under current law. The third thing it does is it allows for alternative ways to test for cannabis DUI using, quote, any bodily substance, close quote, which includes saliva for testing. This is an expansion of the current law of breath, blood, and urine. And then it keeps ordinance and civil violation disposition of minors confidential to reflect the intent of the Juvenile Court Act and limit collateral damage to minors for possession of small amounts of cannabis. Governor Rauner issued an amendatory veto, which is a power given to all governors in the 1970 Constitution, which allowed them to make changes. How big those changes can be has been a constant source of debate between governors and the General Assembly, but his veto, amendatory veto, did three things. It reduced the amount of cannabis subject to this civil proceeding from 10 grams, 15 grams to 10 grams. It increases the minimum fine and the maximum fine from 55 to 100 minimum and 125 to 200 maximum, and it reduces that DUI per se standard from 15 nanomillimeter blood to 5 nanomillimeter of blood. That's on the amendatory veto calendar. The third bill that was, and this is a total veto, amends the Common Interest Community Association Act. It's Senate Bill 1344, introduced by Senator Bill Hayne of Alton and Representative Dan Beiser of Alton. And it provides that no action to incorporate a common interest community as a municipality may commence until an agreement agreeing to incorporation has been signed by 51% of the members. This is a reduction down from current law that requires 2/3 of the unit owners to agree to incorporate. Governor Rauner issued a total veto on that because he believes that Illinois should maintain a higher threshold for initiating the incorporation process because we already have more units of local government than anyone else. The next bill is amends the Personal Information Protection Act. It's Senate Bill 1833, introduced by Senator Daniel Biss of Skokie and Representative Ann Williams of Chicago. And it's an expansion of the current act that protects information that triggers a breach of notification to consumers, including medical information outside of federal privacy laws, biometric data, contact information if combined with identifying information, and login credentials for online accounts. The bill also requires entities holding sensitive information to take reasonable steps to protect the information, to post a privacy policy describing their data collection practices, and to notify the Attorney General's office when breaches occur. Governor Rauner's amendatory veto did three things. It would delete from the two terms from the protected personal information. One would be, quote, consumer market information, close quote, and the second thing would be, quote, geolocation information, close quote. The second thing it'd do is would require the notice to the Attorney General within 45 days, calendar days of a breach, instead of the bill's 30 business days from the breach of privacy. And the third thing it'd do, it would delete the requirement that the operator of the website post a privacy policy. The next bill I'd like to talk about is, you've probably been reading about, it's the bill to require binding arbitration. It's Senate Bill 1229, introduced by Senator Don Harmon from Oak Park and Representative Mike Smitty from Port Byron, and it amends the Illinois Public Labor Relations Act to require binding arbitration if there's an impasse after mediation for an expired collective bargaining agreement between a unit or units of employees and state agencies. The final bill I'd like to talk to you about amends the Juvenile Court Act and the Children and Family Services Act. It's House Bill 3507, introduced by Representative Robin Gable of Evanston and Senator Donnie Trotter of Chicago. And it amends both of those acts to require DCFS to continue to provide services assisting abused and neglected youth from the ages of 18 to 21 that are in the care and the wardship of the court. Governor Rauner vetoed this bill because he believes this was an unfunded mandate that placed a significant financial burden on DCFS. Thank you for listening, and we'll see you again.